Good afternoon. I'm Jaya Calder from High, and it's great to have you on our How to Get the Best Chance of Success with Intellectual Property webinar. Now, before I pass you on to my colleague Andrea McCall to introduce our speaker this afternoon, I'll quickly go over how we run the webinars. We're recording today's session and happy to share the recording with you afterwards. Now, although if you come in as an audience, you're automatically muted, we'd love to hear from you via the question box at any point throughout the session, and we'll get through as many questions as time allows at our Q&A. So, over to Andrea. Thanks.
Thanks, Jaya. Welcome, everybody. It's great to have you all here today. I'm Andrea McCall. I work in the Life Sciences team at High in Inverness. And just to give a bit of context, about NEXUS. NEXUS is our co-working suite in Solasta House on Inverness campus, where we have life sciences and technology companies co-locating and collaborating. And NEXUS is funded by the Inverness and Highlands City Region Deal and ERDF. And the NEXUS webinar series is really an opportunity to find out more about people who are in NEXUS, associated with NEXUS, collaborating with NEXUS, and all the community that goes along with it. So without further ado, I just want to basically come to the introduction for our speaker, Dr. Kate Macdonald. And Kate is actually one of our NEXUS tenants. So she is located within our co-working suite and runs her company Capella IP Limited from there. So Kate will tell us a little bit more about IP and how it can bring business benefits to your business, and it might be also benefits that you actually didn't consider before. This is something more unusual potentially. And we definitely invite you to come forward with questions that can also be quite specific about your challenges, but please, just a reminder, don't share any confidential information on this webinar because it is public and we are recording it as well. Okay, yeah, just without further ado, over to Kate then.
Okay, let's see if this will work. So I'm hoping that you can see my screen, is that right?
Yes.
Yes.
Wonderful. Hello, everyone. I am delighted to be here today. Thank you to Andrea, Katrina, Jaya at High for this opportunity to speak about IP. If for any reason the technology fails and I drop out, I will rejoin and be back with you in a minute or so. We have a few backups planned. We don't, however, have any fire drills planned, so please take note of your nearest exit. And if you do hear a fire alarm, please make your way out safely. Sorry, I just had to put that in. I'm happy to answer any questions you have at the end, as we've already said, but please don't share any confidential information. I'm happy to give you my contact details as well, and feel free to contact me by LinkedIn or email. I am a UK and European patent attorney with over 25 years experience in the IP world. Some of that time has been spent in small businesses, some in large law firms, some in LifeScan, and when it was part of J&J here in Inverness, where I led the innovation team for a while. Our team here at Capella IP is varied, with Alison, a seasoned patent administrator and physics graduate, and Lisa, an experienced PA and history and politics graduate. We as a team call upon experts and partners in other law firms in the UK and elsewhere, and currently have relationships with multiple US law firms, as well as law firms in France, Germany, Italy, Australia, China, Japan, Hong Kong, and India, just to name a few. Here at Capella IP, we are very privileged to work with inventors and innovators and entrepreneurs within the technology and life science sectors, and within the creative and third sectors here in the Highlands, and indeed throughout Scotland and the UK. We also, as you heard, offer our services globally, effectively exporting those services before the UK and European IP offices to clients throughout the world. As a team, we've been doing a lot of work lately to understand and explain better to our UK-based clients how developing and implementing clear IP strategies can put businesses in a stronger market position. Indeed, we want to empower innovators to use IP with skill and understanding to drive results. And I'll say that again, to drive results, to get you where you want to go. I do feel privileged to be part of the community here in the NEXUS Hub. on the UHI campus, surrounded by such Inverness campus, surrounded by such passionate, able and creative technologists who, like us, want to make the world a better place, one innovation at a time. Indeed, within the broader business community within the Highlands, we all innovate. How can we make this, do this, build this, create this? And I want to add, how do we protect this? It is important and often forgotten, and that is what I want to talk about today. The reasons why IP, intellectual property, is an important part of a business toolbox. The creativity here is phenomenal, and I would like to help if I can. Sharing what I know is how I can do this. As we emerge from lockdown, we have all been forced to pivot, to innovate. This is a time of real challenge, but also real opportunity, if we can look forward and rise to it. If for whatever reason you need a boost to get you or keep you going on this journey, Amy Cuddy does a fantastic TED Talk on building yourself up. She recommends standing tall on 2 feet with hands on hips like a superhero for a few minutes every day. It really does help improve your own personal attitude. And indeed, innovation can be thought of as the attitude you bring to a problem, whether this is a business, creative, people, or technology problem. So wherever we are now, how do we look forward? How do we use our creativity, skills, and passion to drive our businesses and our business community to survive and to thrive, opening doors and creating opportunities? Well, IP can help by a surprising amount. Your chances of success in business improve with attention to IP, intellectual property. The IP might be a brand name, a registered design, a copyright work, an invention, and may include social media names. I don't mean you have to file a patent or a registered design or keep keep the original of copyright works or create a protected registered brand name. But if you go through the process of thinking about whether you could and whether you should, your chances of success will improve. A 2019 study on high growth SMEs and IP rights by the European Union IP Office found that SMEs that have filed at least one IP right are 21% more likely to grow in the following 3 years and 10% more likely to become a high growth firm. Prior trademark filings are found to be better predictors of high growth potential in consumer-orientated industries, providing a 49 to 62% increase in likelihood of high growth in such industries like furniture and jewellery. As an example of how this has been used well, we might look at Anta just up the road. As we might expect, indicators based on prior patent filings turn out to be particularly good predictors of high growth potential in high-tech industries. The likelihood of high growth is 110% higher for SMEs that have filed a European patent. Interesting that the predictive power of patents is also very high in low-tech industries, such as food products and textiles, where the prior filing of a European patent is associated with a 172% increase in the likelihood of that SME subsequently experiencing a high growth period. This latter finding is a good illustration of the ability of patents to reflect the competitive advantage that firms in a low-tech sector can gain by innovating. Now, this study indicates correlation, but not causation. Whether this is the discipline of the process of protecting IP, or the process itself, or the results of the protecting of the IP is not clear. But anything that increases the likelihood of success has got to be worth thinking about. So, what is IP, intellectual property? Let's start with what we mean by property. I own the pen I wrote this talk with, I own a car, I own a brooch I might wear, but I do not own the design of the pen or the car or the brooch. I do not own the trademark, Bic for the pen or Ford for the car, but someone does. Someone owns those creations. They are intellectual creations of the mind. Ownership of those creations of the mind is a different form of property, intellectual property, or IP for short. Laws to protect IP are developed on a country-by-country basis. There are several flavours: automatic free rights, such as copyright, These automatic free rights cost nothing in terms of money, but do require time, energy, and discipline. These include copyright, confidential information, unregistered design right, passing off. And there are registered rights that you have to apply for that do cost money, as well as time and energy and discipline. These are patents, registered designs, and registered trademarks. In a moment, I will talk in more detail about these different kinds of IP. But first, I'll just touch on what are the policy reasons behind these laws on a country-by-country basis. A patent is an exchange. You get exclusivity in the form of a monopoly, limited in time and geography, and in return, patent applications must disclose their technology so that others can learn from it and improve upon it. We all stand on the shoulders of giants. That's a big hint here. Technology companies can avoid reinventing the wheel by looking at patents. Approximately 80% of technical information found in patents is not available anywhere else. The value I see added to a business with a proposal for even a low-tech product by carrying out a patent novelty search is immense, providing technical, market, and player insights, again, not available elsewhere. Patents focus on how to make things work. And what is more, most patent documents describe inventions that are dedicated to the public and free to use. For example, patents may have lapsed, or the application for a patent may have been unsuccessful, or the renewal fees may not have been paid, or it may just be time expired. Just because technology is old doesn't mean it is outdated. Indeed, sometimes older technology may have a reduced risk profile, making it more acceptable to the market. At UCL in London back in March, they disassembled an old off-patent CPAP ventilator and recreated it as a Mark I, seeking a regulation derogation and making 10,000 of them within 45 days. They then made a new one, a Mark II, and developed a full open source license model to allow third parties to use it. They could have sought a patent for Mark II and signed up to the Open COVID pledge for companies with patents, making the technology free to use during the pandemic, but not later. But they chose not to. That's a story for another day. Closer to home, at the beginning of the pandemic, 4C Engineering developed a face visor and a process to make the face visor and offered a free, simple license to third parties to use what they were doing. Well done, guys. Back to the social policy reasons behind trademarks. Trademarks provide distinction of goods in the marketplace. Think types of baby food. Would you buy it without knowing who made it? We buy branded products because of the reputation of the company behind the brand. We rely on that brand to demonstrate the quality of the products we are buying. So I'll try and go through this quickly, but we just need to touch on a few essentials about the different kinds of IP. And I also want to make sure you understand that you can use multiple IP rights to protect a single product. When it comes to protecting children, no parent puts all their eggs in one basket. We wrap them up warm, we make them wear cycle helmets, and we teach them not to wander into the road. Similarly, there are multiple ways to protect each product or project. We have patents for inventions, trademarks for brands, copyright for documents, registered and unregistered designs for designs, trade secrets for know-how. There is therefore a basket of protection you can wrap around each new product or idea, or around your business, so that if one layer fails, it is still protected by another layer. Indeed, that 2019 study also showed that this bundling of IP rights is another particularly strong indicator of the likelihood of high growth. So here are the essentials. Patents are for new, inventive inventions. In return, these inventions will be disclosed to the public. The Patent Office will examine the application to determine whether the stringent requirements of novelty and inventive step for granting a patent are met. You must keep your idea strictly confidential until you have filed a patent or decided not to. Patents are strong rights and demonstrate, as all registered rights do, a real commitment to the business idea, project, or product. Copyright is free in the UK at least, and arises automatically for original expressions when these are written down or come into existence. For example, books, music, photographs, art. Trademarks are distinctive graphical signs or indicators of the source of a product or service and can be in the form of words, logos, colours, sounds, animations applied to the owner's products or services, which distinguish them from the products or services provided by others. They can be unregistered or registered. Registered trademarks are also strong IP rights and also demonstrate, as all registered rights do, a real commitment to the business idea, product or project. Registered designs protect the external appearance of a product, not its functional aspects, so not how something works. That's patents. These include surface decoration, ornamentation, as well as shape. To be validly registered, designs need to be new and have individual character. The artistic aspect of a design may also be protected by copyright. Unregistered designs also enjoy some protection. An unregistered design is a free automatic right that you get when you present a design to the public to protect functional designs such as UK shapes. UK design right protects original non-commonplace designs of the shape or configuration of products from copying. Trade secrets cover confidential information not known to the public. It might be technical or it might be business related, customer lists, business plans. The information must be kept secret, not generally known, have commercial value because it is secret, and have been subject to reasonable steps under the circumstances to keep it secret. So here is a basket of rights. I'm really sorry for those of you who've seen this before. I just love chocolate. The Aero chocolate bar was introduced in the 1930s. They got a patent for a chocolate bar with bubbles. They also got a patent for the manufacturing process for a chocolate bar with bubbles. They then applied, or at some point during that process, applied for the registered trademark Aero, which lasted for a very long time. The patent expired after 20 years, so 1950. They also kept a trade secret, chocolate with bubbles of the same size. Did we see a competitor product in the 1950s? No, we did not. The first competitor product to this, as far as I'm aware, makes a good story anyway, is the Whisper chocolate bar. So for 50 years from so they applied in 1930-ish, it expired in 1950-ish, until 1985 when Whisper came out, no one else put a bar on the market, either because the brand was too strong, or because they thought the patent was still in force, it wasn't, or because they didn't know how to make chocolate with bubbles of the same size. Now, as some of you chocolate aficionados know, the bubbles in Whisper are smaller than the bubbles in Aero, equally delicious. And they possibly could have got, for that new, narrower process of how to make bubbles of that size, might have been able to get a patent, I don't know. They certainly would have been able to apply for a registered design for the shape of the chocolate bar, or the shape of the wrapping and the design of the wrapping, and a trademark for the name Whisper. Although it doesn't actually say it's got a little R next to it on there, maybe it's on the back. So here is an overview of how different IP rights can add to the balance sheet. Again, this is this idea of a basket of rights. For each project, you might have one patent or two patents, a couple of invention records, you might have 7 copyright, you might have 3 registered designs and some unregistered designs, you might have 4 domain names and 2 trademarks. You might make sure, for whatever reason, that you've got the right agreements in place. Confidential information is kept very, very close on a particular project. So there are many components to building a successful business. IP is not a friend or a foe, but simply a tool that you can use to secure market exclusivity or market access. Be aware of IP and how it can work to your advantage and disadvantage. So, what is more credible or investable? Is it this scenario 1? Brand, no trademarks, no domain names, and so on. Design and copyright. We haven't taken care of our copyright documents. No unregistered design rights, no patent applications, and we certainly haven't looked at IP arrangements for third parties or directors or employees. Or this one. 1 trademark, 1 registered trademark application in process, 5 social media names on LinkedIn, Twitter, and Facebook. 8 domain names, 1 patent application, 3 inventions in progress. Unregistered design rights may exist. Creation is documented. You've said this in your slide. This is your one-up slide as an overview summarizing your more detailed activities in respect of intellectual property. With that further supporting documentation as the foundation under this one-up slide. This is demonstrable evidence of a compelling story of protection for your proposition. This is a powerful slide to be able to use and talk sensibly about with third parties you want to impress. Now, I want to talk about a few case studies. I've added a couple in since the last time I did this talk. For some of you, you may know who they are, so it could be interesting if you figure it out. Case study 1, an SME with a medical diagnostic device filed a patent application with one of the larger firms and then came to us. And for various reasons, we rewrote it. They filed a couple of trademarks and registered designs, had various domain and social media names, and used marking, etc. So they use the copyright symbol or the registered trademark symbol on their marketing materials carefully and consistently. When speaking to distributors and investors in the USA and Canada, they were able to produce a one-up IP slide on IP. It wasn't that one actually, and talk sensibly about it. They remarked to me that in the US, they were always being asked about IP, but once they developed a decent understanding of IP and used a one-up slide, it just became a non-issue. Any barrier just melted away. Their confidence and their credibility to those they were speaking to increased significantly. They are still in business a decade later, still trading successfully and expanding their distribution network widely across the globe. Case study 2. An individual with experience of running and supporting entrepreneurial companies and individuals had a design for a product to assist a large, well-known UK institution. Could have been patentable, bit of a gamble, and it would either work quickly or would not work, and he wanted to limit his spend. We identified unregistered design rights in the design, and after consideration, decided to supplement that with a registered design in the UK. He also developed a project name, but did not go so far as a registered trademark. Importantly, alongside the design, he clearly and specifically identified how using it could save his intended customer time and money. The approach to the institution was accepted, at least in the first instance, in part because they had demonstrated commitment to the idea and knew the market need of that institution. He created the design himself, but for creative companies that use third-party designs, ownership of copyright and design created by those third parties may be an important issue to address early in the relationship. Case study 3, a young entrepreneurial individual had an idea for a product in a low-tech market he knew extremely well as a youngster. He knew the market, he knew the lead competing product. His understanding of customers, marketing and promotion in this sector was immense, but he had fewer skills on the engineering side as yet. He had an idea for a product. He set up a new company. He'd kept the product strictly confidential, and we carried out a patent novelty search. Unfortunately, or rather fortunately, we found some disclosures that were a problem patent-wise. It was unlikely he would get a patent. He went away. He was very quiet for several months. But he came back to us with a redesigned product. We didn't need to redo the patent search. We could see that this seemed new. It was a better design. It worked better. He also acquired domain and social media names, all to match the market. We filed a patent application. He saw the power of the brand matched by the underlying simple technological product protected by patent pending. He didn't give up after the patent novelty search. He went back and tried again, redesigning and coming up with a better product. He has a dream of where he wants his brand to be and which products and IP will get him there. Very impressive. A young technology company, this is case study 4, headed up by a strong team of experienced entrepreneurial individuals, filed multiple patent applications in their core market and subsidiary markets in their main sector, while seeking investors and attention from enterprise agencies and ultimately a corporate buyout, in which they did succeed. IP, particularly patents, provided a way to demonstrate skill and commitment in their chosen technology areas and a deep and clear understanding of the value of the market for those technologies that were protected. Case study 5. A skilled executive with a thorough knowledge of problems facing billion-dollar projects developed several solutions. I remember the day he walked into my office, patenting those along the way at not insignificant cost. The experience he brought as an individual and the gravitas he developed through setting up a company and filing multiple patent families, as well as his disciplined and professional approach to handling confidential information and business relationships, resulted in his securing, firstly, a joint venture, then EU funding, then a license deal, as well as now the possibility of a sale of what? A tiny business, but a very thorough, very proven, very relevant, very market-driven, very money-saving technology, protected and defined by IP. We encapsulated that here at Capella IP for our clients. I'm smiling because my daughter's ringing me on the phone. To be able to talk sensibly about IP is helpful. There are many fancy words that can be used, but the main reason for spending some time on IP is that having done so, it can open doors, facilitate conversations, engender confidence and gravitas in your offering. Instead of being a barrier, having a handle on IP can help overcome reservations of third parties, such as potential customers, suppliers, distributors, and investors. Fancy words. IP is a business tool. This includes using it as a marketing tool to encourage customer loyalty to your exclusive brand, or to use IP rights by marking on your marketing material to ward off third parties who may be thinking of encroaching on your space. Food for thought. It is a team effort. Together, everyone achieves more. And I don't mean a team who reports into you, although it might include that. I mean a team of co-visionaries or professional advisors like us who challenge, debate, listen, and sometimes force you to listen. Your professional advisors should be people you trust to be part of your team and pull out all the stops for you. Yes, we want to make a living, but it is our mission to really empower you, to empower innovators and entrepreneurs to use IP with skill and understanding, so it becomes that business tool in the toolbox to open doors, facilitate conversations, and ultimately drive results. Human networking is more important than you think. If you always do what you've always done, you always get what you've always got, and that may not be enough anymore. So keep an open mind. We can all make a difference. Opening your mind to all the tools available to you can help hugely when you're faced with challenges. And don't underestimate the tools in the business toolbox, and that includes IP. In this session, we've had an overview of intellectual property. We've thought about IP as a basket of rights. We've thought about using a one-up slide on IP to back up your offering to third parties. We've thought about IP as a business tool, not a barrier, and we've touched on the importance of the attitude you bring to the tools available to you. Over to you, really. So you will be sent, I hope, this slide with these various links on. These online tools are free to use and can help enormously raising your understanding and awareness of IP. So thank you for listening, and now I think we have a little time for questions.
Thanks very much. We've had a few questions sent in, but we can always take more. So as you have been doing, please use your question box just to submit questions as we go along. The first question that's come in, Kate, is how do you actually get started in thinking about IP?
Well, that's a really good question, actually. IP is a big subject. There is a lot of free information out there. And if I go back one slide, I would suggest having a look at this. I don't know if I can do that with my, here we go, here I have a pointer. The UK IP health check is a very good place to start. There's a few tools under the IP for business tools on this link here. There is There's a slightly easier one to use than this that's just a set of short videos, definitely worth watching. Can't remember the name of it, but it sits next to the IP health check. The IP health check is a little bit more in depth. Once you've got a little bit of a basic understanding, it's well worth doing the IP health check. It's a series of modules that have been put together by the UK IP office and professional advisors in a series of questions, and you answer the questions and they'll deliver you a confidential report. You don't have to put anything in there that you don't want to. You just, have you made your invention public? Yes. Well, it'll kick you out because you can't now get a patent. And it's really important to keep inventions strictly confidential until you filed a patent or decided not to. But I would suggest the IP health check is a really good place to go because it has modules on trademarks, designs, copyright, patents, licensing, and so forth. The IPR help desk from the EU is also very good for practical case studies. And then these are a couple of business networks, IP Awareness Network and Anti-Copying in Design, which are particularly good for, particularly the anti-copying in design for creative industries, that sort of thing. The other things on this list, such as TM View or Design View or Espasnet, are search engines for the various intellectual property rights that are registered. So you need to know what you're looking for, or be looking for a particular company or name or product. And the EPO Inventor Handbook is much more in depth, a lot of learning in there. So I would start with the IP health check as a first place to go to raise your awareness. Once you have a business idea or a product or a project in mind, or you may already have one in mind, IP health check is the place to go. Then speak to a professional advisor such as myself, because you then have to tailor the situations to it. But there's a huge amount of information out there that's all for free.
Okay, thanks. The next question that we've had come in is, can software that includes open source coding be patented?
Yes. So the big news is that software can't be patented. Ha! Everybody knows that. Well, in certain circumstances it can be if that software has, and I'm quoting European law on this, if it has a technical effect. So for example, what was the case I came across the other day? It was demonstrating the lungs visually. So they were taking measurements of the lungs and then they were putting an image of the lungs and how much air was being undertaken on a screen, all software. But actually it helped the healthcare professional to understand how much the lung capacity was and how it was changing. So it helped the interaction with a machine. I'm not quite sure which machine. And that is eminently patentable because it has a technical effect. So it's not a question of open source software. It's a question of, does the software have a technical effect? The source code per se, software as an oven by itself is not patentable, but software that has a technical effect, an effect in the real physical world, is patentable.
Okay, thanks. Next question. Can you use IP search tools to find out more about your competition?
Oh, yes. Yes, you really can. I was doing a little bit of a nosy around a search yesterday, and it was really interesting because the supplier who my client was using has just announced something, and guess when I did the search tool for the something, I had a look on Espasnet for the something, it turned out to be the same supplier that had been used. So you can really find out about commercial relationships when you go and look through the power of Google or Bing or DuckDuckGo, and the power of Espasnet to search for technology, or trademarks to search for brands. You can really begin to understand what the relationships are between the different companies and what they might be up to. Sometimes you can find collaborators, sometimes you can find things that you think, oh, that might be an issue to us in terms of launching a product, let's go talk to my professional IP advisor. Or sometimes you can just find technical information about long dead patents that actually have overcome a particular problem that you're concerned with. You can search through company names, you can search through names of designers, you can search through names of inventors. So it really can be a way to understand who's at the forefront of a particular area, whether that's a business area or a technology area, who's innovating in this space.
Okay, thanks. Next question is someone who is a small sole trader. Is IP still for them?
Small sole trader, is IP still for them? Oh, another example from only the other day. Yes, I think it is. I think IP can be a very useful tool, particularly the free things that arise automatically. So having good documented records of your creations, if you've created a new something or other, can be very useful. If you've created a new design, you might consider registered design, proving that you can do it. If you're selling, for example, this design on Amazon, you might want to prove to Amazon that you came up with it first. You might, to go through their dispute process. So it can be very important for small sole traders. Small sole traders might be very interested in making sure that they've got the domains and social media names tied up around the particular way they want to present themselves to the world, that ties in with their brand, so that they might have, I don't know, 5 or 6 domain names. But what's wrong with, there was a company I used to give an example for, and they had I think they had 1 domain name, but why do you only have 1? We've currently got 8, I think, for Capella IP. And they all point to our main domain, because that way it's really easy, but it means that someone else to come and sit on our goodwill, if you like, it's much harder for them to do. And you need to do a similar thing and think about a similar thing for the social media names as well. Be on top of that, especially for a small trader. It's so important these days.
That's great, thanks. Now, can we turn to the area of cost?
Ooh.
Can you give an indication how much it costs to obtain a patent or register a trademark?
So a trademark, to the official fees are not that much. To register, but if you use a professional advisor, you might pay anywhere between £500 and £1,000 for it. In the UK, to file abroad, it's more, a couple of thousand for an international trademark application, possibly a bit less. It will depend on your professional IP advisor. You can file registered trademarks yourself. It is not straightforward. Well, not to me anyway, but it is a thing that people do. You don't have to file for a registered trademark straight away before you start trading. Unlike patents, if you're interested in a patent application, you are generally not advised to file it yourself. You're generally advised, even by the UK IP office, to use a professional IP advisor such as myself, a patent attorney, a registered patent attorney, I should say, or a registered trademark attorney, who is regulated by the IP Regulation Board, because of the training that we bring. And it's certainly it is said, and I have to say I probably agree, that patents that have not been drafted by a patent attorney are quite possibly not worth the paper they're written on. That's not always true. In my over 25 years, I have seen a couple of good writings a couple of times done by non-professionals, but it is pretty few and far between. So for a patent application, for something that's relatively simple, it might be as little as £3,000 plus the official fees, which are not that much. And there are a few hundred. And for a more complicated technical patent application, just to get started, might be anywhere between £5,000 and £6,000. A UK patent all the way through to grant in total might be around between £5,500 to typically around £7,000 to £8,000 all the way through. And there are other costs if you want to file internationally. You don't have to, but there are other costs if you do want to do that, and they can increase quite exponentially down the line. So you've got to know what your market is. The chap who filed that design could have gone for a patent application, but he just said, no, it's not worth it to me. I don't want to do that. I'm going to go for registered design. I understand the difference between the two. I understand I'm not going to be able to stop one from producing the same thing that looks different but does the same function. I get that. He just decided it wasn't worth it to him. He just filed a registered design.
Thanks. And thanks to the audience for your engagement. The questions are flying in and it's much appreciated, and we're still welcoming more. So our next question is, how do you avoid the pitfalls of IP?
Oh, that's a good question. How do you avoid the pitfalls of IP? I'm not quite sure what the pitfalls are. Pitfalls is cost, not using it sensibly, I suppose. The pitfalls, it's a big question. I think there are more pitfalls in not thinking about IP. Making a positive decision to use or not use IP is a positive decision. The pitfalls of IP is only doing the IP. IP, that's probably one of the biggest ones, I would say. And when I have a discovery session with our potential clients, I will always make it clear that it is not the IP that makes money. Deals make money. That's what makes money. You need to make a deal. That might be selling a business. It might be selling a product. It might be developing a license structure. It could be all sorts of things, but you need to make a deal. Usually it's selling product, not always. So you need to have a think about how you're going to make money and then wrap the IP around it to support that business plan. Your business is more important than the IP. The IP is merely there to help you support your business and get you where you want to go. Yeah, so that would be the pitfall I would put number one. IP is not the be all and end all. The company that actually is on the verge of a sale to a, in view of their licensing and EU whatever, their IP was the foundation of the deal, but the deal was always the end game. It's not, the IP is not the end. The IP is not the be all and end all. The deal. And the deal comes from what you as business people can do, where your talents lie in developing products that want to sell and in making connections with people who want to buy.
Okay, thanks. Still got another couple of questions to get through. And this time we're going to look at the area of non-disclosure agreements.
All right.
On question about a non-disclosure agreement, I'm hoping to discuss with my project with a university. My feeling is that we should have an NDA in place even to discuss what additional help they might be able to offer. Should we have an NDA in place, and can you outline any circumstances where this wouldn't be necessary?
So the way I like to think about at the right time to put in place an NDA is the first thing you do is you make the phone call. Hi, I want to talk to you about Project X. We're looking for someone who can do A, B, C. Do you have anyone who can do that? Yes, we do. Right, okay, let's talk about that then. Okay, shall we put an NDA in place? Put the phone down. Then you put the NDA in place. And I say this with universities particularly because you don't put bright people in a room and not expect them, and you have to be quite careful about this because an NDA does not cover this, and not expect them to brainstorm, because they do. So you do have to be careful about that. An NDA covers the technological disclosure around a discussion. So the risk of not putting it in early enough is that, could you just explain why you need this? So that, oh, we need this because in Project X we're going to do X, Y, Z. Okay, right, well, then so you've then stepped over that line of I can't tell you anything about it technically. So you just have to be very aware that of the difference between a conversation that is not protected by confidentiality and one that is, because an NDA will help you to protect the confidentiality of that conversation, which will allow you to file a patent application later. The risk actually with putting an NDA in place before you put in an IP ownership agreement is that you do start brainstorming. And so an NDA does not cover ownership of IP. An NDA covers only the confidentiality of that conversation. So if you do start brainstorming with that university before you're ready to decide where the ownership lies, or before you have decided, then you don't own it, the university owns it, and that can be a problem. So just be aware of those steps. Phone call first, or whatever, Zoom call. NDA to explore what the skills and relationship might be, and to discuss what the project needs are without giving away your secret source, and then an IP ownership agreement. So a 3-stage process so that you know who's going to own what.
Thanks. Our next question is, if someone wanted to start working with Capella IP, what's the process?
Ooh, what's the process? Well, first of all, send us an inquiry, get in touch, that would be great. We offer a 1-hour discovery session of up to an hour. Doesn't always take that long, sometimes takes a bit longer. We don't charge for that. A lot of professional IP advisors will do the same. Some might offer 30-40 minutes. We offer an hour just to explore the issue. I am obliged to keep everything that is shared with me from potential clients confidential by my code of conduct, professional code of conduct, as indeed all professionally qualified and registered IP advisors are as well. And I'm also obliged to carry out a conflict check just to check that there isn't a reason why we can't act for you. You know, we don't act for people in the same space. It's just not fair. It's against the code of conduct. So after that, what we'll do is we'll make sure you've got all the tools, such as the free links there. And we ask you to just have a little think about whether or not you want to go to the next step, because the next step is onboarding you as a client. Bit of a pain in the neck, we write a letter of engagement and so on, but it's our welcome process to make sure you understand how we're going to work together. And in fact, that little step of onboarding you as a client is an example of how you as a business should be thinking about when you're engaging with third parties, whether that's distributors, suppliers, whoever. Right, okay, we need to get you on board. We need to make sure we understand how we're going to interact together. So you put in place an NDA or a material transfer agreement. You might put in place terms and conditions. If you're going to use that subcontractor to develop things for you, you might want to put in place IP ownership arrangements. That might be covered by the terms and conditions. So what we do, that process of going through that with us, is actually a good example of how to work with third parties in general. So we'll draft a letter of engagement, it'll come to you, and we'll outline our costs and cost estimates for you to have a think about whether or not you would like to then take things further. And we're always here on the other end of the phone to answer questions and help you go through the process of thinking about what you're doing with IP. It's remarkable how sometimes a quick call to us can solve a thing that's stopping you from moving to the next step in whatever business decision you've got to do. But it really is our passion to give you those tools around IP and those processes of thinking, right, I'm creating something right now. Do I own it? Do they own it? Or who do we want to own it? Where should this sit? How do I document it? How do I protect it? What am I going to use? I'm not going to use that. Right, forget it. Next thing. Oh, I'm going to use this one. Okay, right, I'll give Kate a ring because we're thinking about a patent application. So we'll write an invention disclosure, or we're thinking about a new registered design, or we're thinking about just documenting this design. So part of that process is really to help you understand what's going to happen through the steps going forward. That was a bit of a long-winded answer, sorry.
Well, thanks. Now I'd like to turn our questioning to collaboration agreements.
Okay.
When various parties are collaborating to develop a new product or service,
yes,
what protection does a collaboration agreement offer?
Well, that will depend very much what it says. And in fact, I'm looking here at this business to business collaboration toolkit, which I haven't actually gone and looked at in that much detail. But collaboration agreements will typically address who is going to own what IP. And that's quite important because there are some disadvantages in having dual owners, joint ownership of IP. Very often what you want, a slightly better thing to do is to carve it out into particular sectors. So one over here and one over here, and that's fine, you both own, but you do it over here, and then you might have to think about control of the core IP, the registered right, if you've then got licenses to use in different areas. So collaboration can be problematic. I would say IP is always created, and arguments happen when IP, when money is around. People think, oh, I could get money out of this by doing this. So they start to look at where can we generate income from this relationship, and in doing that, you know, you can then start to fall out. Tempers get heated when there's a lot of money involved. So the key is really to think about IP much earlier than you would imagine. So what do we expect to be created in this project? Well, we might expect in this particular R&D project to come up with a project name. We might have 2 or 3 registered designs. We're certainly going to have some unregistered design right. We're going to have lots of copyright and database right. We might come up with 2 or 3 inventions. Okay, guys, we're sitting around the table now. We don't know what these things are going to be. What should we be putting in our collaboration agreement to take care of these, so that we know where the ownership sits? What are all these worth to us? And that's about negotiating and collaborating, which I'll leave up to you clever guys who do that sort of thing on a day-to-day basis with companies on the other side.
Kate, thank you very much. That was absolutely great. Now I'm just going to pass back to Andrea McCall from High. Andrea.
Thanks. Well, Kate, that was very insightful, and it's great to hear that even, you know, thinking of IP and thinking through the different types of IP for your business can help you make business decisions and can help you be clear about, you know, what your strategy as a business should be or could be. And obviously, you know, it would be great to see you helping other people going forward, similar to the case studies you described. But I also just wanted to highlight for everyone on the call that the innovation team at High can also sometimes support IP-related queries. So I've just put up their website address here. They also have a nice innovation newsletter you can sign up to, and their email address is here as well, innovation@highend.co.uk. And if you are an account managed business, then you can just contact your account manager for support as well. And the very last thing I wanted to say is that we're looking for your feedback. So you'll get a feedback emails or kind of survey sent to you after the webinar closes, so please complete that. We're always looking for feedback on the webinar, on the speaker, and on any future topics we might want to include. But we also have a SurveyMonkey link that will be sent out in the follow-up email alongside the further reading links that Kate has provided. And our next webinar will be on the 17th of September, and we're looking forward to hearing from Dr. Adam Giangreco from UHI. He will talk a little bit about applied research on commercial activities within the Health and Life Sciences department at UHI. So I hope you can join us then, but please look out for your follow-up email. And thank you very much again for joining us today. And thank you again, Kate. It was a really great talk today.
Thank you.
Thanks,
Bye,
and thank you for joining us. Bye-bye now.